So, where to start? The most sensible place is probably with a reminder of the importance of proper disclosure, so that is where I will get going today. An understanding of the requirements and issues surrounding financial disclosure is fundamental for family lawyers. It impacts on every case that we deal with day to day. Financial disclosure, or the lack of it, governs the extent to which we can advise our clients and provides the framework for the court to adjudicate in line with its statutory powers. Section 25 of the Matrimonial Causes Act 1973 provides that the court has a duty to have regard to all the circumstances in the case, and this includes the financial resources of parties to the marriage. This means that the court has a responsibility to consider all issues, not just the ones the parties may or may not raise. The wide ambit and inquisitorial nature of the court's role was confirmed in D&D and B Limited, 2007, and Sharman and Sharman, 2005. This obligation flows through into other parts of family law where financial disclosure is required, such as maintenance pending suit and legal cost provision, variation applications, and claims under Schedule 1 to the Children Act 1989, as well as prenuptial agreements. Moving on now, procedural update. So there have been two major changes in terms of presentation of disclosure. One is the new, much longer Statement of Information form, and the other is the use of a composite asset schedule in litigation. Starting with the new form D81, to the bane of most family lawyers, this is now a much longer and involved form compared to the previous 6-page D81. It's now 22 pages, and at sections 8 and 10 requires an explanation of the pre- and post-consent order positions. And at section 13 requires a rationale for the division of assets. This runs up a client's costs as more work is involved. However, I can see the justification for it. I understand that the previous D81 was considered unsatisfactory, and this had been a gripe of the judiciary for many years because it doesn't particularly assist the court in assessing the overall fairness of the agreement. We have a snapshot of disclosure, but what we don't have is a clear picture of the effects that implementation of the settlement will have on the respective financial positions of the parties. This requires a judge to get out a calculator and work it all out, which all takes time that judges don't really have. So, streamlining mechanisms have been put in place, which force family lawyers to crunch the numbers instead, and to present a much clearer picture of the start and end positions and the reason why this is considered fair in all the circumstances. There's also the expectation that the D81 will be completed jointly by the parties, and the court will not, unless there's a good reason, be presented with two separate forms, potentially containing different figures. The changes do not require that greater disclosure be provided, though. Rather, they are to allow for greater clarity and assistance being provided to the court.